And so today we've come to hear from Professor Ronald Coase. Professor Coase came to the law school in 1964. He taught courses in regulated industries, economic analysis, public policy. He was the editor of the Journal of Law and Economics from 1964 to 1982. And then he had some ideas. One of his ideas became known as the Coase theorem, and more about that in a second. Another of his ideas on the nature of the firm, or what we might think of today as the firm's size or make and buy decision, sort of really, it's no exaggeration to say that these two ideas alone are maybe the two of the most important ideas that the world has known. I mean, these are two really, really, really big ideas. And any one alone would have been enough for a Nobel Prize. Any one alone might have been enough to be a member of this law faculty. But the two together are really sort of an accomplishment that deserves to be celebrated year in and year out. And indeed, we weren't alone in seeing that. And Professor Coase, as you know, was awarded the Alfred Nobel Memorial Prize in Economic Sciences in 1991. Several years ago, the law school, the Olin program, and many of our friends began offering a periodic, indeed more or less an annual lecture called the Coase Lecture, with an eye towards making law and economics, the website says, more accessible to students. I can't imagine how that could possibly be, but I would say even more accessible, especially to first-year students. And so we've had a series of terrific lectures aimed at the first-year class, but of course to which others have been invited. Professor Al Sykes, I think, offered the first of these lectures in 1992, and there's followed a terrific series, one after the other, members of the faculty, people interested in law and economics. Many of these lectures have now been published in a book, and the lecture series continues. So please join me in celebrating the Centennial Coase Lecture and in welcoming, as he is welcome here every day, Professor Ronald Coase.
Thank you very much for that introduction. I'm very happy, for more reasons than one, to be able to participate in the centennial celebrations of the law school. Nonetheless, as the Dean indicated, it's a somewhat strange experience for me to be giving a Coase lecture. After all, any lecture I give is a Coase lecture. The situation is made more awkward since the ostensible purpose of this lecture series, at least in part, is to honor Ronald Coase. We are told to honor our mother and father, but there is no commitment to honor ourselves. Indeed, for most of us, it would be unnecessary. As Adam Smith said, we do not normally think of anyone as being deficient in self-love. The situation is made even more awkward for me, since the subject on which I've decided to speak is law and economics, and I can hardly avoid giving a good deal of attention to my own contributions to the subject and how I came to make them. I'm afraid all this reminds me of Mr. Toad in The Wind in the Willows. I hope you know what I'm referring to, but I wonder. Anyway, when the Dean asked me to give this lecture, the thought of Mr. Toad led me to hesitate. But when the Dean asks you to do something, in the end there is little to do except tremble and obey. So here I am. Dean Levmore also told me that what I should do is to acquaint the students, particularly the first-year students, with the problems of one of the subjects taught at the law school. I naturally chose law and economics. I have crafted this lecture to interest the students of the law school. Indeed, much that I have to say is autobiographical in character, since what I did as a student and young instructor, and even later, illustrates the part that students play in the development of a subject. Others, not students, may listen in, but this is not intended to be a public lecture. I regard my audience to be the students. My lecture is intended to interest, instruct, and encourage the students. The autobiographical character of my lecture has another advantage. It enables me to describe the curious change of events that led to the emergence of that new subject, law and economics, and which has affected its development. In giving my view on law and economics, you should remember that I am not a lawyer. I am a professor of economics, not a professor of law and economics. Such knowledge of law as I possess comes from some courses I took as an undergraduate at the London School of Economics, studying for a Bachelor of Commerce degree in the years 1929 to 1931. As part of the curriculum, I took courses in commercial and industrial law. I cannot remember all the courses I took, but they included the law of contracts, the law of employer and employee, then called the law of master and servant, the law relating to trade associations, workmen's compensation, and others that I cannot now remember. I greatly enjoyed these courses with their discussion of cases, and I read the law reports and followed the precedents back to discover that the original cases on which the doctrines were based were completely different from those to which it was subsequently applied. The law courts are situated in the Strand in London, a few hundred yards from the London School of Economics, and I went there to follow the proceedings and to admire the quick wit and acting ability of the barristers. We were also made acquainted with some of the important American cases. I remember reading an article by Goodhart on the Palsgrave case, in which a railway guard, helping a passenger to board a train, knocked a package from his arms. The package contained fireworks, of which the guard was ignorant. There was an explosion, and the concussion knocked over some scales some distance away, which injured a woman who then sued the railway. The decision in the American courts was the opposite of that come to in the British courts in a somewhat similar case, Smith against the London and South Western Railway. Well, I greatly enjoyed these discussions. In preparing for this lecture, I looked at a book reprinting Goodhart's article. While turning the pages, I noticed a reference in a footnote to Rylands against Fletcher. It was like seeing the name of an old friend with whom you'd had a special relationship, but the nature of which you had completely forgotten. The fact of the matter is that I enjoyed the law courses more than any of the others I took. This is understandable, given the nature of the others. Take accounting. We were told about the different but acceptable ways in which depreciation or the cost of materials taken from stock could be calculated, or the value of goodwill determined. This was extremely flexible. It never seems to have bothered these accountants that these different procedures all resulted in different profit figures. It was a perfect course for an enrolled accountant. I also took psychology, including industrial psychology, in which we were told about a study at the Hawthorne plant of the Western Electric Company in Chicago. This studied the motivation of workers and the need to be considerate of their feelings. I also took a course in statistics, which was very useful, and others such as business administration, the contents of which I cannot now remember. At this stage, it was the law courses that most interested me, and I suppose had nothing intervened, that there was a good chance that I would have ended up as a lawyer. But something did intervene. And here my tale illustrates the importance for a student of being at a place where not only the faculty is good, but which also has a good student body. In my case, what intervened was the appointment at the London School of Economics of Arnold Plant as Professor of Commerce in 1930. Plant had previously been Professor of Commerce at the University of Cape Town, South Africa. I attended Plant's seminar at the end of my second year at LSE, about 5 months before I completed the coursework for the BCom. It was a revelation to me. He told us how the pricing system controlled production, of the importance of property rights, about the working of a competitive system, and also the government regulation was commonly designed to protect special interests. This was heady stuff and all news to me, being at that time a socialist and never having taken a course in economics while at LSE. But Plant was no theorist, and his views, serviceable and robust though they were not very precise. I discussed Plant's views with my friend and fellow student, Ronald Fowler, and also with economic specialists at LSE, among whom I remember Abba Lerner, Victor Edelberg, and Vera Smith, who became Vera Lutz on marrying Friedrich Lutz of Princeton. As I had not taken any courses in economics, it was these discussions with fellow students in 1932, plus the reading they led me to, that made me an economist. They were a remarkable group. Abba Lerner will turn out later in my tale, but I remember Lionel Robbins telling me how he went to visit Abba Lerner in his flat in the East End to discuss the theory of international trade. Well, Abba Lerner was discussing the theory of international trade when Lionel Robbins noticed that the twins, Lionel and Marion, were busy eating the News Chronicle. The sight of two children eating a newspaper rather disturbed Lionel, and he wasn't able to concentrate on the theory of international trade. Later on, the children brought up the News Chronicle, and Mrs. Lerner came in, tidied up things, and all this time, Abba was discussing the theory of international trade and was completely undisturbed by what was going on. He was a man devoted to economic theory. As I say, at this stage, it was likely that I would become a lawyer rather than an economist, and for a very special reason. As it happened, I had passed the examinations of the University of London for the subjects taken in the first year while still at school, high school as it would be called here. As a result, since 3 years residence at the university were required before a degree could be granted, I had to continue in residence at LSE for another year before obtaining my degree. I decided to spend the additional year studying industrial law. However, no doubt as a result of Plant's influence, I was granted by the University of London a Sir Ernest Cassel travelling scholarship for the next year. I had been interested in the question of why industries were organized in different ways, and I decided to go to the United States to study this question, working under Plant's supervision, the requirement of residence at LSE being somewhat loosely interpreted. I could have chosen any country. That I chose to go to the United States was, I feel sure, due to the fact that most of the literature on business administration and industrial organization was American. That I am able to give an account of what I did there is due to the fact that I corresponded with Ronald Fowler, my friend and fellow student, and he had kept many of my letters as well as drafts of his replies. My aim while in America was to find an explanation for why industries were organized in such different ways, the problem of vertical and lateral integration, as I put it. I also took with me another problem. Plant was opposed to government schemes for coordinating production. The pricing system would do all the coordination necessary. Yet, in his lectures on business administration, he spoke of management as coordinating the work of the various factors of production used in the firm. How could one reconcile these different approaches? Why didn't the pricing system make the firm unnecessary? Here in my investigations, I benefited from having taken a Bachelor of Commerce rather than an economics degree. With all its faults, we did get acquainted with what went on in business in the real world. The result was that when I went to America, I did not spend most of my time visiting economists in American universities. Indeed, in one of my letters to Fowler, I refer to the views of academics as bilge. What I did was to visit factories and businesses and discuss with businessmen the problems that vex me. I could do this because of my BCom training. By the summer of 1932, I got the answer to my question. Why were some operations coordinated within the firm by management, while others came about as a result of market transactions? The pricing system, or use of the market, was not free. You had to find another partner to an exchange, negotiate with him, draw up contracts, monitor the performance, and so on. This was costly. It was the comparison of these costs, transaction costs as they have come to be called, with the costs of carrying out the same operations within the firm that determined which would be chosen. This was all very simple, but it had not been seen before, largely because the existence of firms had been taken for granted. The explicit introduction of the concept of transaction costs was also to play an important part in the analysis of the working of the economic system and in law and economics. But all this was to come many years later. When I returned from America, I was appointed an assistant lecturer at the Dundee School of Economics and Commerce, no doubt as a result of Arnold Plant's recommendations. I described the contents of my first lecture in a letter I wrote to Ronald Fowler. It was the first lecture in a course on the organization of the business unit. What we find there is the argument of the nature of the firm. I comment in my letter to Fowler, as it was a new approach, I think, to this subject, I was quite pleased with myself. One thing I can say is that I made it all up myself. As I said in my Stockholm lecture, I was then 21 and the sun never ceased to shine. In 1934, while still at Dundee, I completed the first draft of The Nature of the Firm, revised it in 1936 after I joined the economics department at LSE, and it was published in Economica in 1937. How it was received by my elders and betters is, I think, extremely instructive. On the day the article was published, on the way to lunch, the two professors of commerce, one of whom was Plant, congratulated me on the article, but never referred to it again. The professor of banking, whose name I suppress, said somewhat sarcastically that it smelled of the lamp, by which he meant that it was an academic exercise without real significance. Lionel Robbins, the head of the economics department, of which I was a member, never referred to the article ever, and neither did Hayek, although my relations with them was quite cordial. The only support I got was from my contemporaries, particularly from my friend Ronald Fowler and from Duncan Black, who had been the fellow assistant lecturer with me in Dundee. If this tale has any general significance, it is that new ideas are most likely to come from the young, who are also the group most likely to recognize the significance of those ideas. Professors like Plant may get you going and provide the essential support in the early stages, but once you get going, it is the interchange with your contemporaries that really matters. It is the interchange in a student body that is the cauldron of discovery. I now turn to the problem of social cost, where the tale is completely different, but the lesson to be drawn from it is much the same. When I was appointed an assistant lecturer at the London School of Economics in 1935, my teaching duties included giving a course on the economics of public utilities. I soon found that very little was known about the subject in Britain, and I began a series of historical studies of water, gas, electricity, the post office, and broadcasting to find out what the facts were. In 1950, my book, British Broadcasting, A Study in Monopoly, was published. In it, I explained how it was that broadcasting became a public monopoly, and I questioned the reasons advanced to justify it. I visited the United States in 1948 to find out how a commercial broadcasting system operated. Then, in 1951, I migrated to the United States and started a research project that I called The Political Economy of Broadcasting, based on experience in Britain, the United States, and Canada. The study was never completed, but I wrote a paper, the Federal Communications Commission, which in a curious way was to lead to the modern subject of law and economics. However, and this will interest you as students, this only came about because of a student note in the University of Chicago Law Review. This student note, therefore, played a crucial part in the events leading to the emergence of law and economics as a separate subject. It is sometimes said that I originated the idea of using prices to determine use of the radio frequency spectrum. This is wrong. The idea was first put forward by Leo Herzl, a student at the University of Chicago Law School, in a student note in the Law Review in 1950. The article dealt with the choice by the FCC of the colour television system to be used there. This is what Herzl said. A much more controversial alternative would be to abandon regulation by government fiat altogether and to substitute the market. The FCC would lease channels for a stated period to the highest bidder. I read this article, but at first I was not convinced. There was, after all, the problem of defining the property rights and making sure that these rights were respected. But then there appeared a reply to Leo Herzl's article by Dallas Smythe, who had been the chief economist of the FCC. His arguments were so weak that I concluded that Leo Herzl was right. And I adopted his proposal when I wrote my article on the Federal Communications Commission. But where did Leo Herzl get his idea from? It came from Abba Lerner's book, The Economics of Control, that Leo Herzl read in 1944 or 1945. Abba Lerner was, of course, one of the group of students at the London School of Economics from whom I learnt my economics. And in the preface to his book, he acknowledges the influence, among others, of Arnold Plant. However, Abba Lerner was a socialist who thought that a socialist system could be run in such a way as to reproduce the optimum results as described in economic theory, in the main by imitating the market, but not always. I remember that he went to Mexico to persuade Trotsky that all would be well in a communist state if, among other things, prices were set equal to marginal costs. Convinced that the use of the radio frequency spectrum could be determined by the price mechanism in the same way as other goods and services, I wrote an article on the Federal Communications Commission in 1958 to 59, while at the Center for Advanced Study of the Behavioral Sciences at Stanford. In the case of radio, the signal of one station interferes with and worsens the reception of others. And this was a real problem and led me to examine the usual approach of economists at that time to this kind of problem. I then studied the work of the English economist Pigou, and he spoke of the difference between private and social products, and he wished to restrain the activity of those harming others. He proposed doing this by means of taxes, but the same result could be achieved in other ways. I objected to the Pigovian approach. We were dealing with a reciprocal problem. Suppression of the harm that one producer creates invariably inflicts harm on that producer. The problem is to stop the greater harm. I illustrated the nature of the problem by examining the English legal case of Sturgis against Bridgman. In this case, the working of a confectioner's machinery disturbed a doctor who occupied neighboring premises. The doctor sued and won his case. I pointed out that although the machinery no doubt caused harm to the doctor, restricting the methods of production that could be employed by the confectioner harmed the confectioner. I illustrated the situation with some hypothetical figures. I said that the doctor would be willing to waive his right if the confectioner would compensate him for the additional costs he would incur in carrying out his consulting elsewhere. I assume this to be $200. The confectioner would pay the doctor up to the additional cost imposed on him by the change in his methods of production, which I assume to be $100. With these figures, the doctor would not accept less than $200, and the confectioner would not pay more than $100 for the doctor to waive his right. It wouldn't happen. But consider the position if the confectioner had won the case, as well he might. The confectioner would be willing to waive his right for a payment greater than $100. The doctor would be willing to pay up to $200 to induce the confectioner to do this. The result is that the confectioner would waive his right. What this showed was that the legal decision did not affect the way the resources were used. As I put it, the delimitation of rights is an essential prelude to market transactions, but the ultimate result, which maximizes the value of production, is independent of the legal decision. While I was writing the FCC paper, Abba Lerner visited the Center for Advanced Study in the Behavioral Sciences at Stanford. He inquired what I was doing. I told him about my argument that the way in which resources were used was independent of the legal decision on ownership. He got the point in about a minute and agreed with it. David Laidler says in his article on Aber Lerner in the International Encyclopedia of Social Sciences that Aber was impressed by my argument and applied it in areas in which he was interested. That Lerner and I so easily agreed was understandable. It was due to what James Buchanan in his book Cost and Choice calls the London tradition, a view of the concept of opportunity cost based on Wicksteed's Common Sense of Political. It was a book that Lionel Robbins recommended that we all read, and I think most of us did. Buchanan quoted a passage from an article of mine that appeared in 1938 as giving a particularly clear statement of the LSE position. And I'll read it to you. The cost of doing anything consists of the receipts that could have been obtained if that particular decision had not been taken. When someone says that a particular course of action is not worth the cost, this merely means that he prefers some other course. The receipts of the individual, whether monetary or non-monetary, doesn't matter, will be greater if he does not do it. This particular concept of cost would seem to be the only one which is of use in the solution of business problems, since it concentrates attention on the alternative courses of action which are open to the businessman. Costs will only be covered if he chooses out of the various courses of action which seem open to him, that one which maximizes his profits. To cover costs and to maximize profit are essentially two ways of expressing the same phenomenon. It is easy to see why, holding this view, I analyzed the case of Sturgis against Bridgman in the way I did. It also illustrates the importance of being at a school at which you learn useful ideas, such as in this case, opportunity costs. However, although the economics department of the University of Chicago is among the best in the world, economists in that department did not see the situation in the same way that I did. They objected to my analysis in the passage dealing with the case of Sturgis against Bridgman, and indeed wanted me to delete it from my article on the FCC. However, I held my ground, and the passage remained in the article as published. I never really understood what the objection to my argument was. I think, but I cannot be sure of this, that these Chicago economists thought that if you possessed a right to do something, your costs would be lower than if you did not possess the right and had to purchase it. In this case, you had to make a payment that would be unnecessary if you possessed the rights. What they ignored, if my surmise about them is correct, is that if you do not use these rights, you could sell them, so that using them yourself costs you what they would have fetched on the market. The cost was the same whether you possess the right or not. This result is, of course, dependent on ignoring transaction costs, but that's quite usual in price theory. Some months after my FCC paper was published, with the error in it, I was invited by Stiegler to give a paper at the Industrial Organization workshop. I accepted on condition that I could also have a discussion of my error. A meeting was arranged which took place at Aaron Director's home with about 20 Chicago economists present. Aaron Director, George Stiegler, Milton Friedman, and others. I have only the haziest idea of what happened. This discussion was hot and heavy and lasted about 2 hours, with Milton Friedman the most active in the discussion. In the end, it was agreed that I was right. The effect on the participants, or at any rate most of them, and certainly on George Stiegler, was dramatic. Stephen Chung, in his piece on me in the New Palgrave Dictionary of Economics, says that, according to McGee, who was present, and now I quote, "As the delegates left Aaron Director's house in a state of shock, they murmured to themselves that they had witnessed intellectual history." End of quote. I did not share this feeling. I could not understand why a statement, the equivalent of 2 + 2 = 4, should be treated on a par with E = mc². As I've said, I have no clear recollection of the discussion. What I do seem to remember as a turning point was when Haber said, if you cannot show that the marginal cost schedule changes, he can run right through. Stiegler wrote an account of the discussion in his Memoir of an Unregulated Economist. But I do not think it is entirely accurate. The tale of the vote before and after the discussion is pure fiction, although I don't doubt that had there been a vote, it would have come out as he described. His account of how I argued also does not strike me as being correct. It's just not my style. However, his statement that I used the example of the straying cattle damaging the crops of a neighboring farmer is undoubtedly correct. I suspect that my argument at Aaron Director's home was much the same as that to be found in the first few pages of the problem of social cost. After the meeting, I was asked to write up my arguments for the Journal of Law and Economics, and that was how the problem of social costs came to be written. In that article, I didn't confine myself to what I'd said at the meeting. I illustrated the nature of the problem by reference to English nuisance cases. I showed that the conclusion that puzzled the Chicago economists was also dependent on the assumption of zero transaction costs, although they are likely, in fact, to be quite large. I discussed what the results were likely to be if you included transaction costs. I discussed the delimitation of property rights, and I ended the article with a discussion of Pigue's views, which have been largely adopted by the economics profession, and I showed that they were erroneous. The article was a great success. It helped to create the modern subject of law and economics. It has been cited more than any other article in the modern economics literature. However, much of this attention does not relate to what I said in that article, but to something called the Coase theorem. This was invented by George Stiegler and stated that under perfect competition, private and social costs will be equal. Coate's reformulation comes closer to what people usually have in mind when they refer to the Coase theorem. The initial allocation of legal entitlements does not matter from an efficiency perspective so long as the transaction costs of exchange are nil. I've never been enthusiastic about Stiegler's Coase theorem, and you've got to be careful of giving other people's names to propositions. I don't like the concept of perfect competition, nor the assumption of zero transaction costs. To make these assumptions is to have a discussion about a world that does not exist, probably indeed one that could not exist. Of course, economists who are used to doing this were able to engage in this discussion of the Coase theorem with enthusiasm. Of course, in making one's argument, it's quite all right to simplify, but this has to be done sensibly. In discussing the trajectory of a bullet fired from a rifle, it's no doubt reasonable to neglect the effect of gravity. But to make the assumption that gravity did not operate anywhere would mean that you don't have a bullet, a rifle, or indeed anything else. And that's what tended to happen in the whole discussion of the Coase theorem. People didn't say, oh, we're neglecting the effect of transaction costs in this particular transaction. They said, in a world of zero transaction costs, which is, as I say, a world that couldn't exist. Looking back, it might have been better if in my FCC article I hadn't been influenced by my courses in law at LSE and had not discussed Sturgis against Bridgman. I could have confined myself to what I said about a newly discovered cave. Whether a newly discovered cave belongs to the man who discovered it, the man on whose land the entrance is located, or the man who owns the surface under which the cave is situated, is no doubt dependent on the law of property. But the law merely determines the person with whom it is necessary to make a contract to obtain the use of the cave. Whether the cave is used for storing bank records, as a natural gas reservoir, or for growing mushrooms depends not on the law of property, but on whether the bank, the natural gas corporation, or the mushroom concern will pay the most in order to be able to use the cave. This approach makes the same point as does the analysis of Sturgis against Bridgman, but does not involve the kind of argument about that case which so upset the Chicago economists. On the other hand, this change of approach would have meant that there was no meeting at the Aaron Director's house, nor any article, The Problem of Social Costs, and very probably no new subject, law and economics. Furthermore, since, as has been plausibly argued, it was the problem of social costs that drew attention to the nature of the firm, there would have been no Nobel Prize in economics for me, and the only bright spot, no Coase Lecture. But God moves in a mysterious way his wonders to perform, and law and economics did emerge and has flourished, propelled by Richard Posner's economic analysis of law. Many lawyers have learned enough economics to make significant contributions to law and economics. The value of using economic concepts, opportunity costs, elasticity of demand, and so on, to aid in the elucidation of legal problems is clear. This work has a solid footing and will continue and develop. The same cannot be said, in my view, of another part of law and economics, the effect of the legal system on the functioning of the economic system, although it is generally agreed that without a well-functioning legal system, you cannot have an efficient economic system. One reason for this lack of interest is that economics has become a theory-driven subject, and the need to carry out the massive empirical work required if you're to do this is not accepted by economists and is certainly not done. But that's a bad reason why the effect of the legal system on the functioning of the economic system has not been carried out. But there's also a good reason. It is relatively easy for a non-economist to learn the economic concepts. It is very hard for a non-lawyer to learn how the legal system operates with its doctrines and terminology. I suggest, therefore, that the study of how the legal system affects the economic system is a task that professors of law should undertake, Not all of them, of course, some of them. I don't think this is a diversion from their main task of training the young. Lawyers in business, and there are many of them, are deal makers. They make it possible for certain transactions to be carried out. Although it may not always seem like this to the client, they reduce transaction costs. I suggest that research projects be undertaken with the aid of students into how this contracting process actually operates. Some years ago, Professor Kitch, then at this law school, undertook with the aid of students a study of the regulation of taxicabs in Chicago. The result was an excellent study which was published in the Journal of Law and Economics. The students proved to be superb investigators. They used rather unorthodox methods for discovering what went on, including talking to the secretaries. I think much more of this work, utilizing the creativity and energy of the young, could be done. It would be good training for work that many of them will actually undertake, and the rest of us will benefit from a vastly improved law and economics. Thank you.
Well, thank you very much. The crowd speaks for itself. And now in the world of who wants to follow that, Professor Coase has agreed to answer a couple of questions before our reception. And so we need just a few brave souls to make their way over to the microphones.
I don't think it's a question of methodology at all. It's a question simply of what economists are interested in doing. I would like them to do the empirical work first and then use their mathematics afterwards to analyze it, instead of starting off with the mathematics and looking around to find something which collaborates, whatever the word is. I had almost brought it along, a quotation from Francis Crick, the English part, half of the team Crick and Watson. And he says that it's very easy to do some elaborate mathematics, which seems to be confirmed by some of the experimental results, and then make a pronouncement, but it's likely to be of no value. And my difficulty in discussing these things is I don't know how to say it without being offensive. Well, I forget what it was that Pontius Pilate was asked about, and he washed his hands. I regard the whole discussion of what is fair and what is just as being a discussion which has gone on a long time and will go on a long time and won't reach any conclusion. It's you know, you hear these sports figures who are going to be given $10 million and they say it isn't fair because someone else is getting 11. Well, you can go on doing that. The reason one can adopt these monetary measures and so on is that they give an answer. It's very important. Adam Smith said, why don't we choose the most worthy person to do these political jobs? The answer is that no one would be able to agree who was the most worthy person. So you have to do some other method. In his day, inheritance, member of the ruling family, or voting, or something else. But you have to have a mechanism for choosing which people can adopt. I don't think you can ever agree on what is fair. I think you need to go to decisions that are important and not ones that are unimportant. You need to go to real decisions and not these experimental decisions. This was something that I didn't discuss simply because I couldn't think of any way of discussing it without being offensive. For example, in my very efficient research assistant gave me, I wanted to know something about it, so he got for me this book on the behavioral law and economics, which has just come out, and I read the introduction, and it was it slightly put me off what was going to come, because on page 2 I read that Ronald Coase was awarded the Nobel Prize for the Coase theorem, which is completely untrue. If you read the citation, it's because of my work on property rights and transaction costs. And it then continues, but various studies have shown that the Coase theorem was wrong. Well, that wiped me off the map, you see. And then I read, or not very carefully, read these articles, and none seemed to me to be dealing with important decisions. There's a lot of discussion about rationality. I don't know what bearing that has on the subject. A lot of discussion about rationality. Well, my view is that the people are stupid. For which there's a lot of evidence. Now, I adopt, roughly speaking, Frank Knight's view. People are rational, also irrational. Now, when do you get irrationality? Well, I adopt the universal law of demand. When the price of being irrational is very high, people don't do much of it. When it's very low, they do a lot of it. You know, if you do something, you're going to get killed. People, however irrational they are in their normal life, avoid it. I illustrate that in my writings by, I talked about people crossing a road to get to a restaurant on the other side of the road and have a sandwich. Well, the more dangerous the thoroughfare gets, the fewer people do it. The reason why we can, when dealing with business decisions, which is what I am interested in, you can assume that people are more or less rational, is if you're not, you're going to lose an awful lot of money and not be able to continue in your business. You know, to buy something for $10 and sell it for $5, it's certainly irrational On the other hand, you're not going to do it for long. And so, and that's true of all business decisions. The effect on the profit is fairly immediate and forces people to be rational. I don't think that businessmen are brighter than other people. It's just they're in a setting where if they don't look to covering their costs, as we put it, they go out of business.
Well, thank you very, very much to all who came. Thank you very much to all who worked so hard to organize the event. And thank you so much to our great lecturer, Professor Ronald Coase.